Good morning.
Good morning.
Good morning, everybody, or the large crowd. We have a much larger crowd online. So welcome and good morning to everybody. Thank you for joining us. Thank you all for being here in person. My name is Mark Moreski. I'm the president of the LPA, and we put these on as Landmark Learns. My first year here, I attended this session with Dan Ahearn, and it was really eye-opening, and I appreciated the information I learned. I come back every year because there's new things, and in addition to my own personal reasons, I also have a lot of parents that ask me questions about different stages of this process. So this is a really great opportunity to have Dan here. A couple quick announcements. I am really honored. I was driving the other day listening to the radio, and I heard My Hometown by Bruce Springsteen come on. And in there he talks about our hometown, and take a good look around. This is your hometown. I'm really honored to be a part of this community. One of the really important pieces of our community is the Landmark Fund. This school is in the business of kids, but it's still a business with a budget, and that budget, I always joke that we don't do bake sales here, but we do ask for people to participate in the Landmark Fund, and I'm really honored to say that at our Landmark Cares, we raised a lot more than we had expected. It was $135,000 and change. Really great, so thank you all. Thank you to everybody online, and really honored to be a part of this group that's so willing. One of the reasons I like to give, and actually my in-laws and my parents have both noticed what a change Gavin has had being here, and they've asked, hey, what can we do to help support the school? And I just said, hey, write a check. If you feel that strongly, please support the school. They want to do it in honor of Gavin. For me, knowing that my donation goes to help kids, the school takes kids that aren't self-pay. They are here through the state and through the towns, and to be able to support that aspect of the school with those donations means a lot to me, and I appreciate all of you and everyone at home making those donations. Page 2. Other LPA updates. Did you have anything, Jackie?
I just wanted to ask about people writing some comments.
Okay.
Appreciation comments.
So
for high school teachers.
High school parents of high school kids online or here in person, we're still looking for people to write words of appreciation. Part of our mission here at the school as the LPA is teacher appreciation. And COVID's a little bit different. We usually have big parties for them because we can't so much with COVID. We're doing things virtually, but as well as handwritten notes, or if you get in touch with Jackie or through Facebook, parents.
Yeah, and it's going to go out in the newsletter today.
Yep.
And we're just getting it ready for the teacher appreciation lunch, which is November 10th.
Okay, you heard it here, November 10th.
It's in the newsletter. It's in the newsletter.
It's in the newsletter today. Read it today. Take initiative. Thank you. That is during milk break. Jackie. Also, EMS event coming up on December 6th. So stay tuned for that if you're an EMS parent. And again, really thankful to Mr. Dan Ahearn, who's going to share a lot of great information. Everyone's path here to Landmark, everybody I talked to has sort of a different path to get here, and mine was probably as unique as anybody's. I'm thankful, I'm appreciative, I love Landmark, and I'm really honored to be able to be a part of this community. So without further ado, Mr. Dan Ahearn.
Thanks, Mark. All right, we are 6 feet away from each other, so you can hear me. I'm going to do this, okay? And also for the people who are live streaming, I think it's easier instead of hearing me go like this all the time that you can hear me actually talk.
And this room is very well ventilated.
This is the most state-of-the-art place in the whole campus, believe it or not, in terms of air filters and ventilation. So, but I will stay at least 6 feet away to keep it clean. Thanks for inviting me, Mark, and Parents Association to do this workshop. I appreciate the opportunity to talk to folks and try to answer some questions. I'm not usually coherent at 8 o'clock in the morning. You can ask the students that I teach every day around this time, but I'll do my best. I stopped at Dunkin' Donuts. Really bad day to stop at Dunkin' Donuts on Halloween. The line was out the door for munchkins and everything else. But I got my coffee, so I survived. The format for today is, I told Jim Coons, our tech guy, that we keep it really simple. I'm going to work off a handout. Instead of dealing with the technology of PowerPoint and stuff like that, we're just going to go straight up, and you're going to have to listen to me drone on for about 45 minutes. As part of this, you can ask as many questions as you want along the way. I think we have a way to pick up some from the stream that we can try to navigate as well. So feel free to interrupt. If we start to run out of time, I will keep it moving. It's my job as a teacher to do that too. So we'll see how we do. Just for a little bit of context, I also told Mark that I also coach soccer here. It's actually more fun to coach soccer than to talk about the law. But we're here to talk about the law. My background, just so you know, is I was a senior attorney at the Disability Law Center in Boston for a number of years, representing kids with disabilities against school districts, against the state of Massachusetts. I litigated in federal court and in state court for a number of years, and then also lobbied at the State House on behalf of the Disability Law Center in terms of legislation. From there, I went and became the director of the Bureau of Special Education Appeals in Massachusetts, the dreaded BSEA, if you've ever experienced it. It's the place in Massachusetts where every dispute involving special education goes. So there's around 10,000 rejected IEPs a year that we handled. There are 8 mediators that mediate cases, and there are 7 hearing officers. And I was in charge of that for about 7 or 8 years. It's a lose-lose position because everybody walks away unhappy most of the time. But I have good depth of experience in terms of that framework. I write material for the Mass Bar Association. I'm starting another chapter for them now on special education law. I run 2 to 3 workshops a year for lawyers in Massachusetts around BSEA hearings, around special education law basics. And I also teach at Suffolk Law School children and disability law. So I only tell you all that so that you have some appreciation that maybe I know a little bit about what I'm talking about some of the time. Not all the time, but some of the time. So we'll try to work through this today, and just so you have a packet. And I'll refer to, we're not going to wade our way through the whole thing, but this is designed to be a reference point for you all in terms of having material to look at and kind of get a roadmap on as the thing unfolds. So let me just get a sense. I can't get a sense from the remote folks, but how many folks have children at EMS? And how many at the high school? Okay, helpful, great, thanks. So this packet is designed to talk about the law in general. I'm going to talk about Section 504 briefly. I'll talk about that a little bit more for the high school parents, something to learn about moving forward from Landmark. And then we'll start to talk about the way the IDEA, or special ed law, kind of unfolds when a child enters that special education system. So kind of one step at a time, and we'll see how this goes. Okay, so if we go to page 2, these are the key statutes, and again, this is legal. This is a great way to start a weekend, talking about the law. Right? So, key statutes in special education, there are 3 of them. I think you know these, that we worry about primarily in Massachusetts. One is the IDEA, the Individuals with Disabilities Education Act. It is long overdue to be what's called reauthorized by Congress. It was last amended in 2004. So usually it's supposed to be changed about every 5 years. You know the deal in Washington, nothing is getting done. So this has been languishing for a long time. There's a lot of things stacked up that need to be changed in the IDEA, but as of now, we're living with a 2004 statute that still is in play. The second statute, which is what we're going to spend most of the time on this morning, the second statute is Section 504 / the Americans with Disabilities Act. And I just need you to be aware of that for a couple of different reasons. IDEA, the first one, is what's called an entitlement statute. Once a child is eligible, your children are eligible for special education, they are entitled to services. It means a school district can't say we don't have the personnel, we don't have the funding, we don't have the resources, we don't have the building, we don't have the program. Once a child is eligible, they are entitled to special education services under the IDEA. In contrast, Section 504 in the ADA is what's called a civil rights law. Doesn't entitle a child to anything, but it protects them from discrimination. And it extends into adulthood, college, employment, etc. Same thing with the ADA. Section 504 applies to places that get federal funding. The ADA plugs a gap and says it applies to places that don't get federal funding. So you look at them together because it's the same analysis. If a student is privately funded here, they are technically getting services under 504. Okay, that's the way we would look at it legally. The plan that's developed with the advisor, with the teachers, is really what we would call the Section 504 plan. Moving on into college, 504 and ADA become really important for high school students to understand. My law class that I teach, usually starting in about 2 minutes, just finished a 2-week project researching their rights in college under the ADA and doing a PowerPoint presentation because it's really important that they understand those rights, and I'll talk about those in a second. The last statute on here is Massachusetts Law, Chapter 71B, and that layers on top of federal law. And the rule of the game legally is that whichever law provides the most protections to a student is the one that controls. So, if Massachusetts law gives more rights than federal law, Massachusetts law controls. If federal law gives more rights to a student, federal law controls. A couple of examples of that. Federal law, for example, says transition planning for high school students should start at age 16. In Massachusetts law says it starts at age 14. So that's an example of where state law gives more rights to a student, therefore that controls, for example. Okay? That's just your general overview of the laws. Any questions about that? Okay. So if we flip the page to page 3, pretend the PowerPoint slide is flipping to page 3. Look at the screen. It's a beautiful screen. Use your imagination. All right? So we're on Section 504, and I'm not going to spend a ton of time on this because it's not directly relevant to all of you and all of you in the audience. If you have other children who are in public schools, there may be some debate going on around, should my child be on a 504 plan or an IEP? And that may come up. And if that's the issue, you need to look at the differences between a 504 plan and an IEP under IDEA. Generally, you can get the exact same services under a 504 plan as under an IEP. However, there are certain rights that do not attach to a 504 plan. You don't have the right to what's called an independent evaluation. You don't have the right to something called stay put. And there's one more that I'm blanking on, but I'll remember it later on. So you need to understand that although you can get the same pieces of services under 504 as you can under an IEP, there are some distinct differences that you need to be aware of. So basically, as you can see here, it says prohibits discrimination, the very first line there. That's the heart of 504 and ADA. And we treat these the exact same way legally because the legal analysis for 504 and the ADA is the exact same. You can see if you go down halfway down the page, you can see it applies to elementary and secondary students and post-secondary students as well. So it applies to both elementary, middle, and high school, as well as college and beyond. If you go to the definition here, further down the page, it says physical or mental impairment. That's the terminology that they use under the statute. And it basically says that if somebody has a physical or mental impairment that substantially limits a major life activity, then they're protected by 504 and ADA. You can see specific learning. If you read that whole long list there, just above C1 there, it says specific learning disabilities are enumerated there directly. If you have a child with ADHD, it might be neurological, for example. Sorry, question?
No, not to interrupt. I guess
interrupt away, seriously.
Thank you. We live in Bermuda, and so there's quite a distinction between education department and health department.
Yes.
And they are very separate things. So you're either in the education department and then you're in the health department once you kind of age out of high school.
Okay.
So here it sounds like the ADA is governing all departments. So
Correct.
it's not department specific?
Correct. So
Okay.
the question is, it sounds like ADA covers all departments, so to speak, or all phases of a child or a person's life.
Yeah.
That's correct. It can apply in elementary, middle, high school, as well as into employment and beyond. So you're right. So it covers a broader array. And that's designed to be an umbrella protection against discrimination. Okay? So if we turn the page to page 4, and again, you can read through, again, this is a reference document that you can look to when you need to. If you have follow-up questions, you can just email me at Landmark and I'll respond. What you can get under ADA and 504 are services and what's called reasonable accommodations. And you've heard that terminology before. An accommodation simply allows the child to access education. It's what are the services or technologies that are necessary for that child to access education. 504 and ADA do not guarantee a level of education. They just guarantee access to the education. And that becomes important later on. I'll mention Part B on the bottom of page 4, harassment and bullying, just so we have that out there, because that's governed by 504 and ADA as well. That's harassment and bullying based on disability. So if a child is harassed or bullied based on their disability, then 504 and ADA trip in to protect that child from that. There are also state laws that can result in criminal penalties for bullying, but harassment and bullying are also covered by ADA and 504. Harassment is something called hostile environment. It means that the environment where the child works or studies has become hostile because the teacher hasn't taken steps to control the classroom environment, the coach hasn't taken steps to control harassment based on disability in that environment. That's a high bar. Bullying is a series of specific incidents. At Landmark, we have a very specific policy that deals with both of these. And we have a bullying policy that's posted on our website. We're required to do that, that talks about how Landmark responds to any instances of bullying, okay? At the bottom here of each one of these sections, I put new guidance. And this is just for your own information if you want to do a deeper dive in your spare time. If you want to go to sleep at night, you can read this guidance from the federal government. But you can see it's a Q&A on COVID. It was published last September. It's a year old. But it's actually a pretty good resource to talk about how kids are going to catch up, particularly kids on IEPs, how they're going to catch up for the lost year, not the lost year, but the diminished year with COVID, okay? So if you're looking for some kind of more detailed guidance around COVID and the requirements under ADA and 504, that's a good thought. Page 5, I added this for you all to talk about college, for the high school folks. When a child leaves Landmark and they walk across the stage in about 7 or 8 months, and they take that diploma from Mr. Barrett or Mr. Bruto, their IDEA services end. Like automatically goes poof, it's gone. What then happens is the ADA and 504 kick into play. And we need to be aware that if the child is going to college, then they need to take some steps, and our guidance office does a great job of this, but you all know you have to get an updated neuropsych evaluation. Legally, it's around 3 years. It's good for about 3 years. Some colleges restrict it to 2 years, and they have that right. But you need to get an updated neuropsych. The pre-admission process, you got to ask a lot of questions. Every college will say, sure, we have great student support services. We will help your child succeed. You got to go deeper than that. You got to ask specifically for what the college will do in terms of accommodations, and I got a list of them here. I would also recommend that as you do this discussion around admitting a child into college, whatever they say, get an email confirmation of that, or a written plan that they spell out for you. I'm working with a student this week who graduated last year in one of my classes, and she is now enrolled in a college. And what happened is she started and she had a calculator and extended time as part of her service plan to help her succeed in college. Last week, they informed her that they're pulling away both of those accommodations. And I said, well, did you have anything in writing to confirm? And she didn't. So now we're going to write a letter on behalf of her from Landmark saying that over the past 4 years, These were standard accommodations that she had and that she needs to succeed. The college's position is, well, she's doing really well. Well, of course she's doing really well. She's got the right accommodations to help her succeed. But my point is, when you have these discussions with colleges, like any place else, you got to nail it down. And nailing it down legally means get it in writing so they can't pull it. I have never heard of a college pulling accommodations after 1 month. Maybe after a semester or after a year, but make sure you get that in writing. So the possible accommodations, you can see a list here. They can get a tutor, they can get extended time, they can get a distraction-free environment to take tests or do writing assignments. They can get a designated note taker in the class to help them capture information when a professor like me is just rambling on right now with no visuals, right, and no ability to keep up with what I'm talking about. You can get a recording or a video recording of the class. You can get specialized housing. We have a lot of students who get singles versus doubles and quads because they need that environment to be able to study at night. Early registration is huge. Early registration means they get to sign up for classes before anybody else in the school. That gives them a huge advantage to pick out professors who actually will work with them versus some professors who say, I don't believe in learning disabilities at all. So you need to be able to navigate that by working through and get to the good professors. And I tell students, if they find a good professor, take all their classes. Right? I mean, be smart about it. No sense in banging your head against the wall with a professor who doesn't want to hear it. Reduce course load. That's a possibility as well. Instead of taking 5 classes, take 4. Instead of taking 4, take 3, especially first semester out. And then finally, focus on the foreign language stuff. Some colleges require a foreign language. You know, on some levels, English can be a foreign language for our kids, right? To navigate the reading and the spelling and all of that. We certainly don't want them to have to try to take another foreign language on top of it, unless they want to, of course. Another student last year had to fight with her college around foreign language requirements, even though she was very clear that she didn't have the ability to successfully manage that. They ended up getting a waiver for a sign language class versus Spanish or French or something like that. So these are just 504 ADA accommodations that you should look for if your kids are in high school and moving in that direction. Questions about that? Yeah.
I have a question that, and I may be getting ahead of what
It's okay.
You talked about when they, you know, graduate, they automatically go from IEP to 504.
Yeah.
So how do we transition them to a 504 before that, and how does that work for a publicly funded kid?
Sure. So the question is, I talked about the fact that once, for example, they take the diploma, the IDEA and IEP disappears, ADA and 504 comes into play. It's a really good question because what I should have mentioned is that nothing will happen unless you advocate for it. So the next step has to be the difference. IDEA, everything is done for the student. Like our advisors track them down and find, why didn't you turn in your homework? Why were you late to class? In college, they don't care, right? It's all on the student to advocate for the services. So what needs to happen is you get that neuropsych, apply to college, then you have to negotiate with the college around what services are necessary for your child. The tricky part is they're going to be 18 at some point, and you're going to get the bills, but you may not get anything else, right? Unless they sign something, your child allows you access to their student records. But you need to work with them to advocate for the services under ADA and 504. Get the neuropsych, get it updated, and then negotiate with the college admissions office and their student support services to get those services in place. Does that help?
And just to follow up on that, parent involvement with those student records. Can you talk a little bit more about that? Are you saying that there's something that you could say, look, the parents are partnering with their student to work with?
When they turn 18 and they go into college, then there's a federal law called the Family Educational Rights and Privacy Act called FERPA, and that basically vests all student record rights in the student, which locks parents out unless the students sign a waiver allowing you access. So that's a point of discussion with your child.
Okay.
Get them to sign that waiver so that you will get reports. So that if something's going on, the college can contact you, or in turn, you can contact the college.
And is that listed in the notes somewhere? particular act, or?
The FERPA Act is not listed in the notes, because that's a whole other workshop.
Okay, I know, it sounds like it.
And Dan, you're saying that triggers at 18 because that is considered
Yeah,
adult
so
done?
you know, and technically, here at Landmark, when a child turns 18, they can shut you out of records. They can tell us that we are 18, we do no longer want my parents to see my student record or share the student record. Technically, legally, that's what happens, and sometimes students will write a letter to the head of the school, which is what they have to do, saying, I no longer want my parents to see my student record. What that means is that you're not entitled to a copy of that record. You can still view the record. You can come to campus and view it, but you're not entitled to copy it or share it with anybody else, unless your child allows you to do that.
And what was it called, the Families and?
Family Educational Rights and Privacy Act. It's called FERPA.
And Dan, most colleges provide that form as part of orientation.
Correct.
So it's a pretty simple process,
Yep.
assuming that your child is cooperating.
Yep, if your child's willing to do it as part of the enrollment packet usually. Yep, sorry.
Yeah, they'll take your money, right, but they won't.
They will take your
Right.
money, yes.
I just wanted to ask about the accommodations process. Is that something that we can work with the guidance department or
Yes.
your child's advisor to say, what are the list of the accommodations you think my child will need to
Yeah.
succeed in college?
Yeah, so the question is, how do we do that here at Landmark? You would work with the guidance office to kind of identify the accommodations and then help prepare information to send to the colleges. And we also spend a lot of time during senior year for students, advising them about their rights. In fact, they're gonna get almost the same workshop that I'm giving you guys, except a little different variation on it from me later on in the year. Okay.
I'd just like to share that. I have a real life story with that as well. My older son's in college and chose his first year to not allow us to have access to his grade. And so we said, that's fine, but you need to excel, not just pass. And if not, we'll talk about it. So this year, we said, after COVID, not always all his fault, but after COVID not excelling, leave it there, he said, hey, we want access to your grades this year. And he said, I'm not ready for that. And I said, okay, well, we're not ready to write the check.
Yeah.
So you can make your own decision here, but so.
Yeah, Mark's point was, for people who are streaming, is that it can happen. For example, his older child, first year of college, did not allow access to his grades. And the deal that Mark struck after first semester, second semester was, that's fine, we need access if you want us to write a check. So, which is pretty fair, right? Pretty fair. So,
He didn't.
yeah, but it happens, so you just need to be aware of that. All right, if we turn to page 6.
So that access can be granted sort of midstream? It doesn't necessarily have to be
Sure,
granted?
the question is, can that access be granted midstream? Absolutely. And that's exactly what Mark's talking about. Everything in special ed law is negotiable. Whether it's with your child, whether it's with a school district, whether it's with a college, everything is negotiable. And always remember that. Never, ever hurts to ask and advocate. Ever. So always remember that point. All right? For those of you who are publicly funded, you know that drill really, really well. You negotiate, you settle, hopefully you didn't go to hearing. All right, page 6, eligibility. All your children are eligible, so we're not going to spend any time on this. I do want to note in the middle of the page, effective progress. It's a definition of effective progress under Massachusetts law, but it's a really, really good measure for you guys to have when you're trying to assess, when you go to the IEP meetings, and they talk about how is my child doing. This is one of the best. It's Massachusetts law. It's one of the best definitions I've seen about how you actually look at, is a child making progress or not? And one of the key variables here is, if you look almost to the bottom of that definition of effective progress, it's the individual educational potential of the child. So remember that, because the Supreme Court actually aligned with that 3 years ago in a decision we're going to talk about. The individual educational potential of the child. It's not measured against standardized tests. It's not measured against what everybody else in the class is doing. It's measured against the individual potential of the child. And we know, having children here at Landmark, that our kids have incredible potential, right? They're super smart. They're super brilliant in terms of thinking out of the box. So we need to measure their success or progress by their individual potential. That's where your neuropsychs come into play. That's one of your benchmarks, those neuropsychological evaluations that you conducted to have your child admitted to Landmark or to be done periodically. That becomes a benchmark for effective progress. Are they meeting their potential? So that's a good thing to file away in the back of your mind if the question comes up during a team meeting or a negotiation about what progress is being made. You can see also there's a list of categories here, and I list the definition of specific learning disability. And you can see that dyslexia is mentioned in that list. It's always been there. Dyslexia has always been there. But what's changed over the past 3 to 4 years is that back in the day, 3 years ago, IEPs were not allowed to have dyslexia listed on the IEP document. There was guidance from state agencies, state departments of education, and nothing explicit from the federal government that said that dyslexia was something that should be listed on an IEP. It was always specific learning disability, SLD, which, as you can see, that's a really big definition. It could cover a lot of different things. What's changed is that there's now explicit guidance from the Federal Department of Education saying that dyslexia can, in fact, be listed on an IEP. Why is that important? I have to ask a question every once in a while. Why is that important? Yeah.
Because there's specific programs that can help.
Yeah, there's specific programs. You know, remember you guys have seen IEPs. How many pages are IEPs? 30, 20. They're big documents. They're as thick as this packet, single-spaced, with grids and stuff. Teachers may have 10 kids in a classroom on IEPs. If it just says SLD, from the teacher's perspective, that could be a whole range of possible issues. But if it says dyslexia, we know it's decoding, it's fluency, it's comprehension, it's those other issues that are more specific that need to be addressed. So it's a procedural thing, but it's a big deal. And we now have dyslexia screening laws rolling in across the country, right? So Massachusetts enacted one about 2 years ago. Legislature passed it, said we need to start doing dyslexia screening early on in Massachusetts, and about half the states in the country now have a similar kind of process. Problem is in Massachusetts, they said we got to screen, but the legislature didn't appropriate any money to do anything about it. So sure, we can find and screen that a kid might be susceptible to dyslexia, but there's no money to follow it. In other words, we found this child, now what are we going to do with her, right? So the key part now is get the money to follow the legislation. And what's happening now federally, there is tons and tons of money rolling from the federal government to the state departments of education. I was with the general counsel of the Department of Education about 6 months ago on a workshop and a panel. They're getting like $1.2 billion in Massachusetts alone to the State Department of Education to fund programming and services. So now's the time to advocate and organize to support the dyslexia screening piece and the services that should follow it. Because identifying does no good if you don't do something about it, okay? Okay, let's go to page 7.
And Dan, just on that page,
Yep.
the age 3 to 22 is because of the idea.
Yes, age 3 to 20, great question, age 3, and again, I'm moving through this. Honestly, this takes me a whole semester to teach at law school. We're doing it in like 45 minutes, so fasten your seatbelts.
Yeah.
It's ages 3 to 22. What that means is that if you take the diploma at any time, 17 or 18 or 19, that ends. But if you don't take a diploma because maybe your IEP isn't being met, or maybe a child has intellectual disabilities that require services longer, it will end at 22, regardless. Okay? Good question. All right, page 7, evaluations. I'm just going to note a couple of things here. You can see at the top there are 3 points in time when a child is evaluated by a public school district. The initial eval, which all your children have been through to identify whether or not the child needs special education services, whether they need to be in an IEP. The reevaluation, which is more common at this stage of the game for you guys, that periodically, at least every 3 years, the school district must reevaluate your child for services. Yeah.
Quick question on that. If they don't, is that a procedural violation or is that something else?
If they don't do it every 3 years, that is a procedural violation. And I'll talk about this later, but it's also legally a substantive violation. So there's procedural, technical violations, like I didn't get my IEP team meeting notice until 2 days late, or I got, when I got the notice of rights that came in the mail. Those are procedural, technical violations, or a typo on an IEP. When a procedural violation causes a substantive harm, that becomes more significant legally.
Gotcha.
Not doing an evaluation would be a substantive harm, because the point of the reevaluation is to make sure that the child's on track.
Yeah.
And a reevaluation doesn't have to wait for every 3 years. If somebody sees something, whether it's a parent or a teacher, and they see something going on with that child and they think it needs to be addressed to change the IEP, for example, then a reevaluation can occur more often than every 3 years. You have the right to waive that reevaluation as a parent. You don't have to have that reeval. If you think everything's going swimmingly and everything is going really well, you've got an agreement to have the child placed here at Landmark for whatever, and you don't want to reeval, you can waive that right. But do it really carefully. Make sure you're not giving away something that you're entitled to, right? The other part about these evaluations is that if a district does one of those evals, the initial, the re-eval, the last one is terminating eligibility, which we're not going to get into. Well, anytime they do an eval, you have the right to an independent eval. And that simply means, and that's listed below there, independent educational evaluation. That simply means that if I get an evaluation over here from, evaluator A, and the school sends me that evaluation, and I look at it and I say, I don't like the font size, I don't like the color, I don't like the format. You don't have to have any specific reason to not like that evaluation. Once you say, I disagree with this evaluation and I want an independent evaluation, the district must pay for the independent evaluation. You can pick the evaluator of your choice to do that evaluation. So in Massachusetts, you have 16 months from the last evaluation to request an independent evaluation. So if I had an evaluation done by the district and I got it today, I would have 16 months from today to get the right to an independent evaluation. Here's the kicker. There's always a kicker legally. There's always a but. The kicker is that they only have to pay for the evaluation to what's called rate-setting rates. Dean Seidel knows this from the business office. We all know about rate setting. The state sets the rate. It says, for this particular evaluation, we're only going to pay up to this amount. So even though it might cost $3,500 for a good neuropsych, the rate might be $1,500. So somehow you got to figure that out. If you go to one of the clinics, Mass General, Children's Hospital, those places, they are bound by the rate-setting rates. So they have to accept whatever the state pays. But just be aware of that. You have the right to an independent eval with some caveat about the rate that you might get reimbursed for that evaluation. You don't have to you don't have to tell the district why you want that independent evaluation. You can pick your own evaluator. You can even go and get the evaluation and then come back and say, hey, by the way, I got an evaluation, I want you to pay for it. You don't have to give prior notice to get that evaluation. Yep.
Like, who would reimburse you for the private evaluation? The school?
The school district would have to reimburse you. Yeah. They have the right to challenge it and go to hearing to challenge the right to an independent eval. It's not worth it for them. They're going to pay us lawyers a lot more money to litigate that than it would be to sign a check for the evaluation. Okay?
So, Dan, what triggers the initial evaluation? Is that the screening that was
Yeah, it could be the screening. It could be a parent requesting an evaluation.
Okay.
It could be a teacher who sees something in class that they're concerned about. That's the initial eval.
And when you're using the word evaluation, is that synonymous with the neuropsych in this case?
In this, for this particular, for our population, yes.
Okay.
Yeah. Yeah. Parents have the right to refuse an initial eval. So if the school calls up and says, we want to evaluate your child, parents have the right to refuse that evaluation. The district has the right to override that by going to a hearing officer if they want to do that. But yeah. Okay? All right, so if we go to page 8, the team process. So think about this handout as the think about this is where a child enters the system and moves through it. So we have eligibility, evaluation, Once we get the child evaluated and found eligible, we're into the team process. So that's where we are now on page 8. And you guys all know the team process. So I'm not going to spend like hardly any time on the team process unless you have questions. You know, I'll note a couple of things there, that at the team meeting, the district has to have somebody there who can interpret tests and who knows district resources. What does that mean? What are district resources? Programs. What programs are available? What money is available? Somebody at that team meeting has to have, quote unquote, authority to commit. Otherwise, we're doing a two-step dance, right? Having a meeting, then we have to go check with somebody at central office, we have to come back. But technically, legally, somebody at that meeting on behalf of the district should have the authority to commit to a program, to resources, to personnel, etc. At the discretion of parents of the district, other knowledgeable individuals. Who might other knowledgeable individuals be at a team meeting?
Advocate.
Advocate, could be an advocate. Who else? Lawyers, could be lawyers. You know, be careful. If you're going to bring a lawyer to a team meeting, just be aware that probably good practice to give a heads up to the district that you're going to bring that lawyer, because otherwise you're going to get there with your lawyer and the district's going to say we need to postpone the meeting because we're going to bring our lawyer, right? So we start the arms race, you know, dueling experts and stuff. So just be aware of that. It does change the complexion of a meeting when the attorney's there. Sometimes you have to do that, and that's okay. And I've done a bunch of team meetings. It's always, Marcus heard me say this before, maybe Michelle. It's always kind of fun if you're a lawyer at a team meeting. This is a little twisted. You know, you take out your notepad and you start scribbling notes, or pretend that you're scribbling notes about everything that's being said. It's a great way to shut up a room. So you just need to be aware of the dynamic or change that occurs when you get a lawyer in the room, for better or worse, okay?
In the meantime, you're making a grocery list, but
Right, exactly. You know, I'm actually doodling away on my notepad or my laptop.
Yeah, I was told early on that bringing an advocate into a meeting was less confrontational than a lawyer. Have the lawyer working behind the scenes, but work with your advocate in the meeting.
Yeah.
And that sort of worked for us.
Yeah, good point, Mark. Mark's point is that he's been told that it's better to have an advocate at the meeting because it's a little less intimidating, but the advocate generally aligns with an attorney who is behind the scenes kind of helping to navigate the process. You know, I'll say this about advocates and attorneys in neuropsychs. There are good evaluators, there are bad evaluators, there are good advocates, there are bad advocates, there are good lawyers, there are bad lawyers. So you just need to make sure, you know, advocates aren't licensed, they're not regulated. At least lawyers have to go before a board and get licensed, and there's a complaint mechanism if they do something wrong. So just pick your advocates wisely. Just because they've watched, you know, CSI on TV and Law and Order and all that stuff, you know, the best lawyers aren't the ones who kind of stand up and stomp and yell and scream. They're the ones who negotiate and figure out a way through it. So just pick your advocates and pick your attorneys wisely. Talk to other parents, referral networks, try to get information about that. Okay? So the team process, again, the only other thing I'll note here is that if your child is taking MCAS, any accommodations that might be needed for MCAS should show up on the IEP. You can't ask for those accommodations at the last minute. They should be built into the IEP process. There is a really interesting new guidance here. It's called Letter to Holler, issued in the end of 2019. And I mention it because I think it's Brookline, actually. And the issue here was that the district was sending central office administrators to sit on the team meetings, and they didn't have any knowledge of the child. So they were just there to kind of listen and observe and contribute when they felt like it. And the federal government in this letter, from the U.S. Department of Education, you can just Google Letter to Holler and put that date in, basically said that the people from the administrative central office who are there, or district personnel, need to have a working knowledge of the child to be a part of that team meeting. Otherwise, they're there for who knows what reason, but you're basically violating FERPA. Again, you're sharing confidential information about a student with somebody who doesn't have a need to know because they're not working with that child. So it's kind of an interesting letter. that kind of frames who should be at a team meeting and who can contribute or not. Page 9 is the IEP. You've all seen IEPs for the most part, yeah.
As a parent, am I allowed, because the district person, and then that's just my personal case, he keeps changing every meeting that we have it at someone else.
Yeah.
My sense it's getting higher up, but it's definitely someone who doesn't have the knowledge of what is going on from the beginning of the process.
Yeah.
You know, as a parent, am I allowed to request the same person at some point from now on?
Yeah, the question is around continuity of who attends the team meeting on behalf of the district. If it changes like from meeting to meeting or eval to eval, whatever. Yeah, can a parent request it? You can certainly request it, right? That's the bottom line. Remember, always ask. Legally, the district has the right to determine personnel, whether it's attendance at a meeting or delivering services.
But I can put
You can certainly request it. Yeah. Yeah, and I would, for continuity purposes, it certainly makes sense. Because if that starts to happen, here's how we look at it legally. If you have a different person every time and the services aren't getting as consistent as they should be, that becomes one of those procedural issues that turns into a substantive violation. Because the district isn't maintaining continuity of programming for your child. Yeah, it's not a technical procedural, but it's leading to a substantive flaw in the educational program.
Because we do have a procedure violation in my case, they forgot about her, so the IEP.
Sure, that would be a problem.
Okay.
Yeah, the comment was they forgot about her, and that's clearly procedural. Okay, on the IEP thing on page 9, just note part number 8 there. You've seen the IEPs, we don't need to walk through those, but the transition services planning, which we start at Landmark at age 14, is a transition planning worksheet. This is one of the major focuses of the federal government when they audit the states, is whether or not appropriate transition planning is occurring. And I can tell you in terms of litigation, it's one of the most heavily litigated areas in special education right now. The argument that kids were not properly prepared for life beyond high school because their IEP transition planning was defective or boilerplate, meaning it was just a template that they plugged in for every IEP. So just be aware that transition planning is a hot button issue legally, and I think we do a good job here at Landmark, but you should also pay attention as your child's advocates and parents to make sure we do a good job. Technically, the district is supposed to be doing all of this, but they work with us on that. Okay, if we go to page 10, services. This is the magic language here. Every child is entitled to a free and appropriate public education. Free is easy. We'll talk about that in a second. Appropriate is the buzzword here, right? Like, what is an appropriate education? There's 2 major Supreme Court cases. One is called the Rowley case, decided way back in the 1980s. And the Rowley case basically said that no child is entitled to maximize their educational potential under the IDEA. Meaning, back in the day in Massachusetts, the law used to be a child is entitled to maximum feasible benefit. Massachusetts changed that law about a decade ago to align with federal law, which is just an appropriate education. So we know under Rowley that it's not maximum, but the question is then what is it? So the Supreme Court 3 years ago in a case called the Andrew case tried to clarify that, and they said what appropriate means is meaningful. I don't know if that helps, but it's basically, it's not, the court explicitly said, it's not a trivial educational benefit, it's not de minimis, it's not maximum, but it's meaningful in light of that child's individual potential. Going back to that language we talked about. So that is an important benchmark. There needs to be meaningful education. And I would go back to that effective progress definition as a way to kind of wrap your head around that, because it's very similar to what the court articulated in the Andrew case. It is important, even though it's not as crystal clear as we might like, it's an important distinction because the lower court in that case had basically said, this is a case out of Colorado, that minimal educational progress met the definition of appropriate. meaning just barely making any progress, satisfied the IDEA. Supreme Court, in a virtually unanimous decision, which is totally rare, especially nowadays, right, basically said totally wrong. De minimis fails the child. Minimal fails the child. We have a higher obligation to give that child something meaningful. So just be aware that you get that free, appropriate, meaningful education under the IDEA. That also means you get related services, which are transportation and things like that. How many people are on settlement agreements to get to Landmark? Okay. How many settlement agreements? Yeah. So is transportation part of your settlement agreement? No?
It
Yeah.
was, so we negotiated it out.
Negotiated it out, yeah. One of the biggest lever points in terms of settlement agreements is the issue of transportation, for example. It can be more expensive than tuition here at Landmark, hard to believe. So districts will often try to settle out the transportation. We'll pay for the tuition, you provide the transportation, or something like that. The transportation is one of those related services pieces. Okay, placement. So we all know about placement because we're here at Landmark. Here's the deal. Under the IDEA, the child must be placed in the least restrictive environment. The least restrictive environment legally is a regular ed classroom with one teacher. If we drop an aide into that classroom, it's a little bit more restrictive. If we pull a child out for 1 or 2 periods a day for reading, small group reading instruction or tutorial, that becomes more restrictive legally. If we put them in a separate program or classroom, that is more restrictive. If they go to Landmark, that's restrictive. If they go to residential, that's the most restrictive placement legally. So the obligation of a school district is to reconcile that free, appropriate public education in the least restrictive environment. So they have to balance at those team meetings, where can a child get a meaningful education in the least restrictive place? Which is why periodically we'll have situations where, for example, a child's at EMS and they hit middle school and the district says, we now think we should pull her back to our regular public school. Or they're transitioning from EMS to the high school over here, same junction point. We think it's time for him to come back to the local public school. That's least restrictive environment. That's what they're doing there. Legally, they're required to do that if they can do it. But they have to make sure they're getting an appropriate education too. So that's the balancing act here. So if we have a situation where, in fact, we've got a child here at Landmark, you have a couple of different options. One, the parents can place the child here and do what? Self-pay. Write the check, right? You can write the check as a private pay, no big deal. IDEA doesn't even get involved. Or you could work with the district, and the district may say what?
No.
Well, they may say what? We're going to go to no in a second. They may say yes. They may say, sure, we agree, we've tried, it's not working, it's the right thing to do, we'll place the child at Landmark and pay the rate setting. Or they may say, no, we think we can meet your child's needs in district. And you come back and you say, you know, we've been at this for 3 or 4 years, it's just not happening, it's a critical stage, social, emotional, all those variables. My child needs to go to a place like Landmark or Carroll or White Oak, whatever it happens to be. You place the child here and you want the district to pay, and the district says, no, we're not paying. A couple things are important to understand. If you're taking that route, the IDEA requires 10 days notice of the intent to place at Landmark if you want to get reimbursed. Or notice at the most recent team meeting. If it becomes contested, you have to basically prove 2 major things. You must prove that the public school program is not appropriate, and you must prove that the Landmark school program is what? Appropriate, right? You have to hit on both of those. If you don't hit on one of those, you will lose the case legally. And if you've done this process with the BSEA, you know that you move through mediation, you move into what's called pre-hearing, you move into the hearing phase, in most cases settle. Statistically, there's about 400 to 600 hearing requests filed a year, and there's about 15 decisions issued a year, because it drives people to settle. Because there's some uncertainty about whether or not you can prove that the district's program is inappropriate and the public school and the private school program is appropriate. So that's the thing you have to navigate. How do you prove that? Neuropsych. You've got to have a neuropsych. If you don't have an evaluator, a good evaluator, you are not going to win anything. And I don't care which side you're on, whether you're a public school district or a parent. If there's not a good evaluator to be able to comment knowledgeably about the public school program and the private school program, you will lose the case. A lot of parents go in pro se, and they think that their heartfelt testimony will sway the hearing officer. It won't. There needs to be expert evidence there to comment about it. If you don't have that, you're not going to be able to prevail in the case. Okay? So just be aware. That's the framework that you need to be aware of. The third component in a very close case like that, and this is moving through the team meeting, moving through mediation, whatever you do, the third little element that's buried in there is what I call balancing the equities, that a hearing officer will look at it and say, okay, this is a really, really close case. Public school program's a little wobbly, but I'm not convinced that Landmark's the right place. They go to a third piece called the equities, and the issue there is basically who has been more reasonable or unreasonable in the process. And that can tip a case. So it's really important when you're preparing these cases, so to speak, that you are reasonable, that you're not acting belligerently, that you're not storming out of meetings, that you're not attending meetings when they're inviting you. You need to be, at least appear, reasonable in the process, because if it comes to that little tipping point, it can turn a case. Okay? So just be aware of that. Who's more reasonable is always an important variable, and lawyers will work with you on that if you have to hire a lawyer. They want to present you in the most favorable light all the way through the process, in case it gets to that stage. Okay. Questions about the placement stuff?
I have a question.
Yeah.
Just, like, if you are moving to a school district and they, or, you know, and you're moving the IEP, or you're, like, they haven't actually gone to that specific public school,
Yes.
do you have is it hard to get a case for them to do this?
So good question. So the question is, you're residing in District A and you move to District B. Does that complicate the placement process? Potentially. What happens legally is whatever IEP you're on in District A must be implemented by District B. So we'll do a couple of examples. If your child was placed at Landmark by District A and you move to District B is obligated to continue to fund that placement until they can come up with an alternative that might meet that standard of being an appropriate in-district program. If, for example, you have an IEP that says they're in a program in District A, and then you move to District B and you decide that based on what you see in District B, you want your child at Landmark, that's going to be a little more complicated, because you have to look at, did District B get an opportunity to meet your requests, or is it too premature to jump to a private placement? Private placements are considered, again, very restrictive, like a place like Landmark. So there's going to be some kind of navigation going on there. Good question. Other questions about the placement piece? Yeah.
If you rejected the evaluation that the school district gives and you asked them to pay for a
Yeah.
private neuropsych, is that the same results you can use here, or would you have to get a separate?
No, you can use, if you get that independent evaluation, you would, the idea would be that you would use it in this context.
Great.
Yeah. And you know, again, be careful of picking evaluators. Talk to other parents, who's done a good job, who hasn't done a good job. If you work with an attorney, I guarantee you that attorneys have X amount of evaluators on speed dial that they work with, that they feel comfortable with. You know, there are some evaluators, I can tell you, if you call me up and you say, I'm working with, you know, this evaluator, I know immediately you're doomed. Okay? Honestly. Because I know the evaluators and I know the hearing officers, and you can figure that out by reading the hearing decisions if you really want to do that. They're very explicit in the decisions. If they have a bad evaluator testifying, they will say it out loud. in that opinion, saying, I find this evaluator not credible because, and I always feel bad about that because parents have invested time and effort and resources to get to this point, but they've got a bad expert behind them, and if you have a bad expert, you're not going to win the case. Your attorneys or advocates will usually work with a pool of people they feel good about.
So I guess my question goes back to the initial evaluation, which it sounds like would come through a district, right?
Yeah.
Either for whatever that trigger point is.
Yeah.
You may decide, oh, I'm satisfied with that, but because is the legitimacy of that evaluation tainted at all by the source of it when you come to a place where, okay, let's say, oh, I live in Wenham, not to say anything bad about Wenham, but like say Wenham says, I'm gonna do an evaluation on your kid, and then I go a year later and wanna have a hard and fast conversation about whatever, but you see what I'm saying?
Yeah.
Like, am I better off going for the independent evaluation?
Yeah, from a legal perspective, I would always say get the independent evaluation, just because it's important to start having those tools available to you.
Yeah.
And it's also, as a lawyer, if I've got a case, I don't know enough about educational practice and theory and all the details, so I rely on the evaluator to give me guidance. So I think it's a resource that's available, so why not use it?
Yeah.
But it doesn't mean that the initial eval or an eval done by a school district isn't credible and helpful. Sometimes they're really, really on target, and those can be really valuable tools in negotiating a program.
Yeah.
Yep.
Okay.
Sure.
Are there any advocacy groups or bureaus that put out a list of some of the preferred persons or?
Yeah, for example, in Massachusetts, there's two groups. One is called SPAN, which is special, I don't even know what it's called. I do a workshop for them every year. But it's an umbrella organization for advocates. It's called SPAN, Special something, Advocacy Network. And that's a good resource for advocates. There's also a place called the Federation for Children with Special Needs, which also does, I'm doing a workshop for them on discipline in about a month. They have a list of advocates as well, and evaluators. It's called the Federation for Children with Special Needs. Those are two good resources for advocates and evaluators. Good questions.
Yeah, just 10 minutes.
Yep.
10-minute warning.
10-minute warning, appreciate it. I will always end on time, I promise. Page 12, we got a couple things here. Records access. We talked about that a little bit. That's FERPA again on top of the page there. That basically gives you access to a student record under the IDEA. Stay put is just something to understand about halfway down E. That simply says that this is important to understand, that if you have a child on an IEP and the district proposes a new IEP, if you disagree with any parts of that IEP, the parts that you disagree with, the old IEP will remain in place until that disagreement is resolved. So this is important for Landmark, if you have a child here on an IEP that says my child's at Landmark, the district comes back at the end, say next April, you have your team meeting, the district says, hey, we have a program in district that we're going to propose to you, here's the new IEP, new teachers, new staffing, new classroom, all the package. You look at that and you say, yeah, but I really think it would be important for my child to finish out at Landmark. So you reject that IEP. While that IEP is rejected, your child stays at Landmark. That's called stay put. That's called placement pending appeal. That's that other right that I talked about that comes into play. You don't get that right with 504 plans, but you do get it with an IEP. And that's a really important point. If you do a settlement agreement, I guarantee you the school district will ask you to waive the right to stay put. Okay? So be aware of that. That's a big leverage point within settlement agreements. The district will always ask parents to waive stay put. So just file that away. That's a significant right under the IDEA. Okay? Procedural violations and FAPE, I already talked about that. The IDEA explicitly says a whole series of procedural violations don't mean a lot unless they start to impact substance. If they impact the child's educational programming, then you have something to be aware of. Lawyers will often say, make a list. Make a list of procedural violations as part of their case preparation process, which is a good idea. Because then at some point you may look at it and say, oh my gosh, we had a case, I was a hearing officer for a case in Nantucket a while ago, and Nantucket had done all the right things, but they had like a whole ton of procedural violations spanning a couple of years. And it became clear that ultimately those procedural violations, although minor in nature, were impacting the educational program. And therefore the child actually did, this is before I came back to Landmark, the child actually got placed at Landmark from Nantucket. So sometimes they can add up, so it's good to keep track of them. And you can bring them and share them with your lawyer. There's a whole bunch of new guidance here at the bottom that just came out. One just came out, the last one there, Return to School Roadmap, August 24th, 2021. One in July as well. All focused primarily on COVID implications for kids on IEPs. So talks about compensatory education and services. It's a very good document as a kind of reference point. I am not going to talk on page 13, 14, and 15 about discipline, because nobody's going to get in trouble. But I'll say this about discipline. Always check the student handbook. So we revise the student handbook, parent and student handbook, every year. It's posted on the website. If, for example, something bad happens here and there's a disciplinary process, the first thing you should always look at is the student handbook to make sure that we are following the rules that we established. Secondly, there are detailed procedures under the IDEA that are on those pages that you can look at to make sure that Landmark is following the right steps and procedures. They're very, very detailed. I tell my law school class that if they can read section 14, 15 of the IDEA discipline and tell me what it means, they will pass the class. They don't have to come to class for the rest of the semester. Nobody ever can pull it off because it's really complicated. But check this out if you ever have to deal with it. The last thing is on page 16, dispute resolution stuff. Before we stop, mediation, if you have a chance to go to mediation, I would always encourage it. The state runs a mediation program, doesn't cost you anything. There are state-appointed mediators, they're well-trained. A good mediator can get something resolved in 2 to 3 hours. So if that's an option, check it out. There are other Massachusetts options. The one that is, two things that are happening more frequently now is called a facilitated IEP, which means that the Bureau of Special Ed Appeals will send out a trained mediator to negotiate or resolve issues that arise during potentially contentious IEP meetings. You can ask for that. The other one is called a settlement conference, where the director of the BSEA pulls the parties together for usually about a half a day to kind of lay out the law and give them pretty direct guidance about if they're going to win or not. You have to have an attorney to do that. The hearing process, has anybody been through the hearing process? That's a good thing. Okay, it's a really ugly process, so hopefully you never have to do that, so I'm not going to talk about that in detail, except you have the right to request a hearing at any time. I would never go into it without a lawyer, unfortunately. It used to be really simple back in the day. You didn't need attorneys. It's been lawyered up, so you actually do need an attorney. Now, if you look statistically, parents who go in without a lawyer lose almost every time. So don't do that. Last thing on page 17, attorney's fees, just be aware of this, that functionally, if you do go to hearing and you do prevail, the district is obligated to pay your attorney's fees. Okay? So that's why it's a high stakes process. If you think about it, for a school district, if they go to hearing, they're going to pay their attorney's fees. They may pay for the Landmark placement. And if they lose, they're going to have to pay for your attorney's fees. That will cost the SPED director their job, guaranteed. So functionally, this is why it becomes really contentious, but that's also why they want to settle. They will want to avoid paying attorney's fees. Another point of a settlement agreement, waive stay put, waive attorney's fees. You have to decide that with your lawyer if you get to that point. But attorney's fees can be a pretty valuable tool. I will say there was a Landmark parent about 5 years ago, had one of their children in a different school district, got a concussion, playing field hockey. This is a publicized decision. Went to the BSEA, argued about services under 504 in an IEP. They lost. They appealed to the federal court. They lost. Went to the Court of Appeals. They lost. Because because the hearing officers and the judges felt that the parents were not reasonable in that process, the court awarded the school district attorney's fees against the parents of about $170,000. So just be aware that none of this comes without a cost. If you go deep into the litigation process, there's risks on both sides, and just be aware of that. Okay, any miscellaneous we've covered a ton of information in a short amount of time. Are there any miscellaneous questions that people have? Yeah.
I'm gonna go back to the 504 IEP
Sure.
thing. So, you said no state put on a 504.
No stay put, no independent eval.
And so at what point should somebody switch from an IEP to a 504 if they're publicly placed? I guess that's how, in like you had mentioned, that happens after they graduate, but who,
Yes.
like the IEP is facilitated by the school district,
Right.
who facilitates the 504?
Yes, so the question is, let's say we have an IEP and the child might consider moving them to a 504. At that point, that means they are terminating eligibility for special ed,
Right.
okay? There's actually a flow chart that the state publishes that they have to do this analysis. If they're terminating a child from IEP services, then they must look to 504, see if that comes into play or not. So at that point, it could be the parents advocating for 504 plan services, or it could be the district trying to shift it from an IEP to a 504. 504 world is run by the regular ed department versus the special ed department. So usually it's an assistant principal in the school that handles 504s versus the sped director. So it's different funding streams too, which is also important to understand. Districts get reimbursed for kids on IEPs. 504s, it comes out of the regular ed budget. So there's a cost there. But that they have to be a team meeting to end eligibility for an IEP and then move the child to a 504.
So is that, like, I know it's important for him to be on a 504, but I don't want to disrupt what's going on with his IEP with his placement. So I guess that's,
Yeah, so
I just the timing of it and can it be done?
it's a timing issue about when to move from a 504 to an IEP. If you've got a child on an IEP, you know, I'd be remiss to tell you that it'd be better to be on a 504. There's simply more legal protections on an IEP.
Yeah.
Any other questions? All right, bye remote people. Thanks everybody.
Dan, on behalf of the front of the
I already stopped it.
Oh, all right, in front of the smaller group, on behalf of the LPA